10:03 this morning, Supreme Court. 2 words that just ended everything. Application denied. 9 justices. 0 disagreements, not even from the ones he appointed. And it happened exactly 72 hours after Melania Trump's lawyers did something no one saw coming. This isn't speculation. This is public record. Court filings you can verify yourself. And if you want to stay ahead of what happens next, hit subscribe now, because this case is moving faster than anyone expected. Here's what just became legally official. Melania Trump gave up her spousal privilege, voluntarily. The legal protection that stops prosecutors from forcing a wife to testify against her husband? She walked away from it, on her own. And what she's offering isn't small. 3 categories of evidence that prosecutors have been building toward for months. First, financial documents. Joint tax returns from 2014 to 2020. 6 years where both signatures appear under penalty of perjury. Tax returns that depend on property valuations. Properties valued one way for bank loans, valued another way for tax authorities. If that's true, that's bank fraud and tax fraud, and both signatures are on the page. Second, communications. Text messages about property values before lender meetings. Emails with accountants where she questioned why banks were being told one number and tax forms showed another. And recorded phone calls. Conversations about specific valuations tied to loan applications. If those recordings exist and she's offering them, prosecutors already verified they're real. Third, witness corroboration. She can confirm what accountants already told the grand jury, back up what bankers said under oath, support what appraisers said about being pressured to inflate values. 1 witness is strong, 2 witnesses is stronger. 3 witnesses with documents? That's a pattern of evidence most defenses can't overcome. Now here's why the timing matters, because this didn't happen randomly. Monday, 2 p.m. Eastern. Her lawyer submits a proffer agreement to the special counsel. A proffer is like a preview. The witness tells prosecutors what they know, what they'll say under oath, what evidence they'll hand over. In return, prosecutors consider immunity. Tuesday, 2 p.m. Eastern. Exactly 24 hours later, the defense files an emergency appeal to the Supreme Court. They want to block her testimony before the grand jury hears it. Their argument? Spousal testimony violates marital privacy under the Fifth Amendment. Filing an emergency appeal in 24 hours is lightning fast. Most take weeks, which means the defense knew this was coming and had been preparing. Wednesday, the Supreme Court receives the appeal, gives it a case number, schedules review. But here's what they didn't do. Issue a stay. A stay means everything stops while the court thinks. No stay means the legal process keeps moving. That silence? It speaks volumes. When the Supreme Court issues an immediate stay, they think the argument has merit. When they let things continue, they have doubts. Thursday, 10:03 a.m. Supreme Court delivers its answer. 1 sentence. Application denied. No dissents. Justice Thomas didn't object. Justice Alito didn't object. Gorsuch, Kavanaugh, Barrett, all appointed by Trump, didn't object either. Unanimous rejection. When the court writes even a brief opinion, it means the question needed explanation. When they issue a single sentence with 0 disagreements, the appeal wasn't worth discussing. The defense made 3 arguments. All 3 failed spectacularly. Argument 1. Spousal testimony violates marital privacy. But 150 years of rulings say spousal privilege can be voluntarily waived. The key case, Trammell v. United States, 1980, ruled the witness spouse controls the privilege. The decision to testify belongs to the witness, not the defendant. That's never been overturned. Every federal circuit follows it. This argument had no legal foundation. Argument 2. The proffer was obtained through force or threats, making testimony involuntary. But the filing includes a sworn statement from her attorney. She reached out to prosecutors first. Her lawyer initiated contact, proposed cooperation, negotiated terms. No subpoena, no threats. Entirely her decision. That sworn statement destroyed the coercion claim completely. Argument 3. This would set a dangerous precedent, destroying marital privacy in future cases. But that precedent already exists. Spouses testify in federal cases regularly when they choose to. Trammell settled this in 1980. What they were really asking for was a special exception based on who the defendant is. The Supreme Court doesn't create exceptions based on identity. The law applies equally. So when the court issued that one-sentence rejection with 0 disagreements, the message was clear. These arguments weren't just weak, they were frivolous. With the Supreme Court appeal denied, the grand jury can hear her testimony within days. This grand jury meets Tuesdays and Thursdays in the Southern District of New York. If prosecutors are ready, and the proffer suggests they are, she could appear as early as next Tuesday. Once she testifies, prosecutors face a choice. Option 1. Use her testimony to strengthen existing charges. The current indictment has 34 counts of falsifying business records and bank fraud. Her testimony about joint tax returns, meetings with accountants, corroborating other witnesses would make those charges stronger. Option 2. Seek a superseding indictment. Add new charges based on new evidence. Watch this closely. The proffer mentions a March 2020 phone call. She was present during a conversation between the defendant and a banker discussing property values before a loan application. If that call included both of them making false statements together, him saying one thing, her confirming it, both knowing it wasn't true, that's conspiracy to commit bank fraud. Conspiracy is separate from fraud itself. It requires an agreement between 2 or more people to commit an illegal act, plus at least one step toward carrying it out. A phone call where both knowingly lie to a bank is the agreement. Submitting the loan application is the step. If prosecutors believe they can prove conspiracy through her testimony, they'll add charges. A superseding indictment could significantly increase legal exposure. This case sets 3 precedents that could reshape federal prosecutions for decades. First, spousal cooperation at the highest levels of power. Mob wives testified in the 80s. Corporate spouses cooperated during Enron. But no one's seen this at the presidential level. Someone who held the highest office, with their spouse coming forward with financial records, communications, and testimony directly implicating them in federal crimes. This changes the game. Future prosecutors building cases against powerful officials now have Supreme Court precedent confirming spousal privilege can't block voluntary cooperation. Second, privilege claims won't delay federal cases. That one-sentence rejection with 0 dissents established a standard. When spousal privilege is voluntarily waived, emergency appeals based on marital privacy will fail. Courts won't let delay tactics disguise themselves as constitutional arguments. Defense lawyers now know privilege claims won't buy time when the witness chose to cooperate. Third, accountability applies regardless of wealth or power. For decades, wealthy defendants used procedural tactics to stretch cases endlessly. Appeals, privilege claims, emergency motions, hoping to outlast prosecutors or wait for political changes. This case shows the system can still function when courts act decisively. The judge maintained a strict schedule. The Supreme Court unanimously rejected delays. The grand jury process continued without interruption. The system worked because institutions held firm. Over the next 30 days, 3 things will reveal the prosecution's strategy. First, grand jury activity. If new witnesses get subpoenaed within 2 weeks, prosecutors are building toward new charges. More witnesses means more counts. Second, the defense response. They'll almost certainly file a motion to throw out her testimony. Standard procedure. But what they focus on tells you everything. If they attack the recordings are damaging. If they attack her credibility, the documents are strong. Defense motions reveal what prosecution evidence is most dangerous. Third, whether the immunity agreement gets finalized. The proffer is step 1. Full immunity requires a signed cooperation agreement spelling out exactly what testimony is required and what protections are given. When that document gets filed, you'll see the full terms. Full immunity, partial immunity, or use immunity, which only protects the testimony itself from being used against her. The Supreme Court didn't write an opinion because the law was already settled. Spousal privilege can be waived, evidence will be heard. The trial is set for September 16th, 28 weeks away. With the Supreme Court appeal denied, there are no more delay tactics, no more emergency motions to block evidence, no more privilege claims. That trial date will hold. So here's my question for you. Is this justice finally working, or does spousal cooperation at this level set a precedent we should worry about? Drop your take in the comments. And if you want real-time updates when she testifies, when that immunity agreement drops, when new charges potentially get filed, subscribe and turn on notifications. This case is moving at Supreme Court speed now. The system worked, not because of politics, not because of privilege, but because the court followed established precedent. And no one, no matter how wealthy or powerful, is above the law.